Let's start. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court of Judicature at Bombay dated 26/04/2022, passed in writ petition number 411 of 2021, by which the High Court has dismissed the said writ petition preferred by the appellant herein. The victim seeking transfer of the investigation to Central Bureau of Investigation or to any other agency to reinvestigate the FIR numbers 119 of 2020 and 120 of 2020 registered at Vartak Nagar Police Station, Thane. The original writ petitioner, the victim, has preferred the present appeal para. The facts leading to the present appeal and as per the case on behalf of the appellant in a nutshell are as under para. That the appellant is a civil engineer working as a consultant, shared on his Facebook account on 05/04/2020 a viral picture of one Mr. Jitendra Kumar, the then sitting cabinet minister of the state of Maharashtra, within bracket, who is subsequently arraigned as accused number 13. After the High Court intervened, criticizing his act or ridiculing the Honorable Prime Minister of India. According to the appellant, at around 11:50 p.m. at night on 05/04/2020, four policemen, two dressed in civilian dress and other two in uniform, came to his residence and forcibly took him to the bungalow of the said minister. According to the appellant, thereafter the minister instructed his men to beat him and make him apologize for circulating the said viral picture of the minister. The minister threatened him to delete the post immediately. Thereafter, an ally of the minister called the appellant on his number as he left his phone in his house and told his wife to delete the controversial post. According to the appellant, he was mercilessly and ruthlessly beaten up by the police personnel present at the premises of the minister. That the appellant went to the police station and he got the information that an FIR bearing number 119 of 2020 under section 292 of the Indian Penal Code within bracket IPC and section 66 within bracket E of the Information and Technology Act has been registered against him by the police on the complaint of one Mr. Hitesh Kumar, accused number 3 in the present case and close ally of the minister with sole purpose to threaten him if in case he decides to file a complaint about the said incident. It is the case on behalf of the appellant that thereafter the appellant without fear narrated the entire incident along with the specific allegations against the minister and the other police officials and registered a complaint against the minister and his men. However, the names of the minister against whom the specific allegations were made and his men were not mentioned in the FIR bearing number 120 of 2020 dated 06/04/2020 for the offences under sections 365, 143, 144, 147, 149, 324 and 506 within bracket 2 in the Vartak Nagar Police Station, Thane. It is the case on behalf of the appellant that the concerned minister was not named in the FIR as he was the sitting cabinet minister in the government of the state. That thereafter apprehending and alleging the bias and alleging that the entire investigation has been conducted in a sham and counsel and casual manner and nothing significant was done by the police. The appellant approached the High Court by way of present writ petition praying for transfer of the investigation of the aforesaid FIRs to the Central Bureau of Investigation within bracket CBI, Mumbai or any other agency. It appears that thereafter various interim orders came to be passed by the High Court in the writ petition and the investigation agency of the state was compelled to carry out the investigation. The police filed the charge sheet initially without naming the concerned minister, namely Mr. Jitendra Kumar, as accused. However, thereafter and during the pendency of the writ petition before the High Court and in view of the constant monitoring of the investigation by the High Court, the minister Mr. Jitendra Kumar was added as accused 2 years after the said incident. That thereafter, during the pendency of the writ petition, the learned trial court framed the charges against the accused on the basis of the charge sheets already filed, which, according to the appellant, was for the lesser offences than the actually committed, like kidnapping, abducting, and causing grievous hurt. That thereafter, by the impugned judgment and order, the High Court has dismissed the said writ petition seeking transfer of the investigation to the CBI and oblique or any other agency by observing that after the investigation, the charge sheet is filed and the High Court prima facie opined that by filing the charge sheet, supplementary charge sheet, the investigating agency has conducted the investigation from all angles and after considering the medical report and even after collecting the CRD of the mobile phone, and that once the charges have been framed by the magistrate trial court, and therefore it can be said that the trial has begun, and therefore thereafter the investigation or the further investigation is not permissible by the impugned judgment and order. The High Court has dismissed the said writ petition filing aggrieved and dissatisfied with the impugned judgment and order. The original writ petitioner, the victim, has preferred the present appeal. Stop. Thank you. Jai Hind. Jai Mera Bharat. That the trial has begun and therefore thereafter the investigation or the further investigation is not permissible by the impugned judgment and order. The High Court has dismissed the said writ petition filing aggrieved and dissatisfied with the impugned judgment and order. The original writ petitioner, the victim, has preferred the present appeal. Stop. Thank you. Jai Hind. Jai Mera Bharat. Jai Hind. Jai Mera Bharat.